you, Dom. And thank you, Dominic, for organising this. I can see there's pages and pages of people here, so that's fantastic. Very pleased to see everyone joining this particular seminar. I know it is an extremely niche area, so I can envisage that everyone is wanting all the information that they can at this stage. And I will shortly be sharing my screen with a presentation. And when I do, it's going to be a slideshow. So it's going to fill my screen. If there are any problems with sound or seeing this slideshow or anything like that, then please just put it into the chat. If everyone can mute themselves, that would be great. It's just so that everyone can hear. And also, as Dominic said, questions at the end, because I want to be able to get through as much as I possibly can within the time frame that I've got. And equally, I don't suppose you want to be here beyond an hour on an evening, because I'm sure we've all got things that we want to do beyond this. But at the same time, I know and I'm hoping that this will be useful for everyone in terms of the information that they want to get in relation to EHCPs. Now, I am going to share my screen very shortly. Bear with me. As Dominic will attest to, I am not the most technologically minded. See, he's already smiling because he knows it. I will. Can everyone see the slides?
We can, thank you.
Brilliant. Thank you, Dominic. Thanks for that. Sorry. I forgot that everyone's meant to be on mute. Okay, so I am part of Slater and Gordon in the education team. We are currently a small team of 2. We have been with Slater and Gordon since February, but I have been dealing with EHCPs for going on 12 years now. And gosh, doesn't that make me feel so very old? But it's been a journey during that time, and equally, I think the journey is about to develop even further. So although I'm going to be delivering this seminar, caveat, this could change very, very shortly. So I'm sure some of you will be aware, and if you're not, I'm making you aware now, and please watch out for it. There are some talks of SEN reforms coming from the government. Now, they were meant to be introduced in November as part of the November budget. However, they delayed it. Hopefully that's a good thing, because it meant they're trying to collate some further information on it. And all they've said is early this year is when we will hear about it. As to what is going to happen, there's been a lot of speculation, a lot of rumours going around. I know parents are already petitioning, so we will have to wait and see what happens. I'm not going to raise any of the points of speculation because there isn't really any point, but already we can see that parents are ready in respect of anything that might be detrimental to their rights, particularly their legal rights in respect of EHCPs, and quite rightly so. It's not an easy system to rectify, but there are ways to attempt to manage it. So fingers crossed that's what will happen. But as of right now, this is what the current system is. This is the current law that I'm about to tell you about. And then as and when changes come in, as I said, please watch out for them. And then hopefully, as I said, they won't be too detrimental. If they are, I can anticipate probably another U-turn. And haven't we had enough of those? But in terms of the EHCPs, it's a relatively new system. I mean, it's been there for the entirety of my journey. I trained with statements of special educational needs, which is what was in place prior to EHC plans. So EHC plans brought in 2014, the most significant change in nearly 2 decades. And it was meant to be an all singing, all dancing system. Everyone's meant to be talking to each other. Everyone's meant to be integrating with each other within the council. You know, clues in the name: education, health and social care. We're all meant to be chatting away together in the best interests of young person and child. That hasn't quite happened. Unfortunately, there were already legal analysts. I was part of various different meetings prior to it being brought in, where everyone sort of was slightly concerned about the integration and cooperation part of it. And unfortunately, that has come to fruition in that the integration and cooperation doesn't really exist, I'm afraid. And it is, unfortunately, as cynical me will attest to, it's much to do with it's not my budget, it's yours. So it is incredibly frustrating. However, the EHCPs did bring in some good aspects as well. One of the most important, it covers 0 to 25. So from 0 years of age all the way up to 25. The 16 to 25 age bracket previously weren't covered as well as they should have been. So this EHCP process brought in a document, a legally binding document for that age group, 0 to 25, as well as the 16 to 25s. It also brought in things like personal budgets and direct payments, which in of itself can be a sort of a presentation all by itself. However, essentially, personal budgets, they could be things you ask for a sum of money for maybe a particular resource or provision, educational, that the council can't provide for whatever reason. Maybe it's not within their resources is normally the biggest reason, but they have acknowledged that it is required to meet need. You can ask for a personal budget. And then that will be given as a lump sum of money, and you have to be able to provide receipts as to how that money has been spent. So that's just sort of a quick little explanation of the personal budgets. So as I said, it's has its flaws, but it also has its advantages in terms of the system. And in respect of, what I will be taking you through in terms of the presentation, as it's going to be sort of an overview of the whole system, background, etc. as well. Children and Families Act 2014 brought this system in. Special Educational Needs and Regulations 2014 was the other piece of legislation. And then you've also got the Code of Practice, Special Educational Needs and Disability Code of Practice. Google search that, it will come up. It's about a 200-page document. It's great, easy to read, much easier to read than legislation. But it will give you an overview of the entire process from start to finish, and the Code of Practice is relied upon by tribunal judges in respect of any sort of decision making, so it is particularly useful, and as I said, easy to read. This particular duty, Section 19 duty, which was brought on to local authorities, was under the Children and Families Act, and essentially they have to have regard to the views, wishes and feelings of the child and parents. Now, the most important aspect of that is have regard to. Doesn't have to follow through on it, I'm afraid. So it simply has to consider the views, wishes and feelings of the child, as well as parents as well. That's normally covered within Section A of an EHCP. Although it's not followed, it is important that your views, wishes and feelings of your clients, of the children involved, or any parents who are on this and have an EHCP, that it's recorded in Section A, and it's updated regularly because it's important those views, wishes and feelings are captured, because I can tell you, if you were to reach a tribunal, the first people that they want to hear from, judges do, is parents and the young person if they can, even above sort of any expert witnesses. So that's how important that is, even though the local authorities simply have to have regard to it. The start of this process, so where we begin in terms of requesting an EHCP, the initial stage is to firstly ask for an EHC needs assessment. This should be pretty simple. I say should be, but as many things during this process, it doesn't quite work out that way. An EHC needs assessment or request for one normally should just be made in writing via letter with supporting documents sent to the Special Educational Needs Department at your local council. And I will come on to the test that needs to be fulfilled to be able to access or attempt to access an EHC needs assessment. However, A lot of councils will probably have their own application processes. So my suggestion would be for anyone looking to apply for an EHC needs assessment, contact the special educational needs department at your council and request the process for applying. The legal test, however, does not change regardless of the application process. So that's important to note. And as I said, I will come on to that. Who can apply for an EHC needs assessment? It can be the educational setting that child may be attending, school or nursery, or indeed college, because this EHCP can be applied for at any point. It doesn't necessarily have to be at the early stages. Medical professionals, GPs, paediatricians, therapists such as speech and language therapist, occupational therapist, any other professionals involved in your child's life that may have an impact, particularly on the educational aspect. And most importantly, parents themselves can make a request for this. They don't have to wait for anyone else to do it. They can actually do it themselves. And the local authority must reply to this request within 6 weeks of receiving it. And that's the first point where you essentially have an answer of yes or no, formally communicated through a letter, and you will get appeal rights either way. And as to whether you are, happy or unhappy with decision. And obviously, if they say no, then that's when the appeal rights will be exercised. Now, the legal test that's applied to be granted an EHC needs assessment, it's really very simple. It's not too arduous. It's a pretty low bar. Part one of the test is that the child or young person has or may have special educational needs. That's usually listed as to what the special educational needs are, and by diagnosis letters. Any diagnosis letters are available. Then part two of the test can be slightly trickier, but I think it very much depends on if there is an educational setting involved, and if there is an educational setting involved, are they in support of the EHC needs assessment? Because part two of the test is looking at what interventions have been attempted within the school or nursery's own SEN resources once they have seen maybe potential cause for concern and for those particular aspects of provision to be tried or interventions to be tried. So they will need to be attempted first, and then if they haven't then worked, that must be detailed. So what interventions were attempted, which haven't worked? Is it the case that all of them haven't worked, or some of them have worked and others haven't? But for the part two of the test to be fulfilled, essentially those interventions should have been tried, attempted, and then not worked. And then it should be listed. And then it should be the case of these interventions were tried over this particular period of time, and they have not worked, or progress has not been made. And as a result, an EHC needs assessment is required. That last bit of wording is so very important. EHC needs assessment is required. Unfortunately, as pedantic as it sounds, if those words are not said, then the council will attempt to try and argue, well, it doesn't need to be granted. Even though the evidence may be crying out for an EHC needs assessment, if it's not specified clearly enough, then they may attempt to essentially, the reasons usually given for not granting an EHC needs assessment is needs can be met through the setting's own SEN resources. And then there isn't any need for an EHCP, because an EHCP brings its own individual funding for the child. When we're looking just the SEN resources of a setting, you're looking at sort of that £6,000 mark in respect of what they have in place for any child within their setting that may display special educational needs. Now, that for some children, those interventions are just required and it can be suitable to meet need, and child then progresses. But for those children that maybe those interventions don't work for, that's where they might need to seek some additional funding, individual to themselves through this EHCP. This EHCP is funded and arranged by the council and then delivered by any particular educational setting. It's important to make that distinction because I know a lot of parents will go to battle with school or educational setting, but they aren't the ones that are ultimately responsible. It is the council who are ultimately responsible for arranging and funding the provision within the EHCP. And equally, they are responsible for the content of the EHCP in respect of writing it as well. Now, if you are granted an EHC needs assessment, fantastic. First obstacle that you've gotten over. If it's not granted, then, as I said, you will get your appeal rights and you can lodge an appeal if you feel the decision wasn't made correctly. I mean, I've seen councils state that, needs can be met through SEND resources, but the school's crying out, saying we need an EHC needs assessment, but still they make that particular decision. And actually, maybe the council haven't even reached out to the educational setting. So in that case in particular, absolutely, please appeal. And when it comes to a refusal to assess, that's the type of appeal that it is, it's decided on paper. It doesn't go to oral hearing in front of judges. It's decided on paper because the legal test is a low bar and it should be pretty obvious from the paperwork submitted as to whether an EHC needs assessment is required. You can ask for an oral hearing, however, those are only granted in exceptional circumstances, and I would have thought very complex cases. Now, when an EHC needs assessment is granted, this is the process essentially that should be followed over, again, a 6-week period. Sometimes it will take longer, and various different professionals will be asked for their advice. Educational psychologists, the school setting itself or the nursery setting itself, therapists involved, all of them will be asked what they feel the child's needs are, what provision they require, and what they should be asked is whether they feel an EHCP is required. Because the next test to fulfill is an EHCP necessary? That's the next question to answer, and that's the next question. We'll get a yes or no from the council. And you guessed it, again, if they say no, we get appeal rights. Now, is an EHCP necessary? It's quite a vague question, I suppose, but the way to look at it essentially is what do the aspects of provision recommended by the professionals and requested by school attract EHCP funding? Or could they meet the provision requirements through their own funding within the school setting? So whatever allocated funding they have for SEN, could they actually fund it from that particular funding allocation? Or is it the case actually they look at the provision recommendations and think, no, we're going to need additional funding to be able to meet this child's needs, hence why an EHCP is needed. This is the entire process from start to finish. And as I said, once that EHC needs assessment process is completed, you will get a yes or a no to an EHCP. And if it's a no, you can appeal. You will get all of the reports that have been compiled during that EHC needs assessment, or should do, to be able to determine how that decision was arrived at. But this is essentially the entire process from start to finish. 20 weeks is what it should be. And this flow diagram comes from the Code of Practice. As I said, meant to be a 20-week process. Unfortunately, it does take longer due to the availability of experts, therapists providing evidence. There is a lack of educational psychologists at the moment, which seems to be one of the major aspects that is holding up this process. You can threaten and pursue legal action by way of a judicial review if certain deadlines aren't met as set out in legislation and in the Code of Practice. However, I would probably advise threatening it, maybe not pursuing it, unless a local authority is outrageously out of time and haven't been providing updates. If the local authority have been providing updates and been letting you know what's been going on as you go along, then that will be sufficient defence in respect of any legal action, because the panel that decide upon it via the JR will essentially say, well, they have tried to communicate what is going on, and then there are certain things that will be beyond their remit. There has been recent case law which has suggested that, for instance, if an EP is not available from the council's resources, then if parent is able to produce their own EP report, this should then be considered. Now, a lot of local authorities, unfortunately, when it comes to independent reports, will not consider them. Then their policy seems to be, we will not consider independent reports. Reason being, unfortunately they are, but fortunately for us, they're far more detailed than council reports, and far more specific in terms of what should be delivered. Hence why local authority may try to avoid looking at those particular reports. But what I can say is they may not look at them, tribunal will. So although the council may want to put their hands over their eyes, the tribunal won't, and the tribunal will consider that evidence and apply it to whatever challenge is before them. Now, if you are fortunate to get an EHCP, congratulations, you will get a draft EHCP, and this is the form it will take, sections A to K. Now, the main element of this plan is the educational aspect. You cannot just have a health and social care plan. Education has to be part of this. It's the main part of this. Now, we covered section A, which is views, interests, aspirations. The other most important sections, well, the most important sections of this plan are sections B, F, and I. Section B is the child's special educational needs. So we're looking at diagnosis, everything that manifests from that diagnosis. Essentially, everything that a school, what to remember is that a school setting is going to look at this document first to determine whether they can meet need. So that section B needs to tell them everything that they need to expect from your child in respect of any needs and behaviour. So it is important that it is tailored to the child's diagnosis and needs. It's normally split into cognition and learning, communication and interaction, physical and sensory, and social, emotional, mental health. Section F is a special educational provision to meet the child's needs. So what is the provision that is required to meet those particular needs? That provision can look like therapies, speech and language therapy, occupational therapy, physiotherapy. It has been attempted to be previously argued that therapies such as those should only go into the healthcare sections of this plan. That is not correct. If the therapy has a direct impact on the access to curriculum, so if it has an impact on the child's ability to learn, for instance, with occupational therapy, if a child has sensory needs, lighting, sound needs to be at an optimum level for them to be able to sit down and learn. That is special educational provision. Sometimes physio programs are needed, stretching exercises are needed to be able to maintain their stability to again sit down and learn. That is special educational provision. Without speech and language therapy, they may not be able to communicate and be able to communicate to sit down and learn and ask questions. Again, that is special educational provision. It is not just healthcare. And if there are any still councils around trying to argue that it is just healthcare, they are incorrect. And please do not allow that to happen. And we'll come on to the reasoning as to why that shouldn't happen shortly, but that should not happen. And you're looking at one-to-one teaching assistance, you're looking at strategies, programs, potentially equipment as well, that should go into section F. All of the provision in section F should be arranged and funded by the council and then delivered by the school. And then section I. So as I said, most important sections are B, F, and I. I is the name of the setting. You'll normally get the type of setting as well as the name of the specific setting your child will attend. And then in respect of the remaining sections, the other sections to keep an eye on, section E, the outcomes. Those outcomes need to be ongoing, need to be revised, need to be looked at by professionals involved and by teachers involved as to what's been achieved for the child and what then needs to be achieved next. Always build on those outcomes. Those outcomes are not built upon and they're all achieved. The council may well decide, okay, there's nothing more to be done with this EHCP. Outcomes are achieved. We can cease to maintain the plan. And that needs to obviously be fought against because I can imagine for a lot of the young people that you work with and the children that you work with, there is more to learn. And that only would apply to someone who, truly doesn't have the capacity to learn anymore. So it's important to keep an eye on the outcomes. This plan is reviewed annually. So that's where you can keep an eye on the outcomes. Section K lists all of the reports used to feed into this plan. Sections B and F, and section I in respect of the advice provided as to the name of setting, that can only be advised upon by professionals. Parents can't ask for changes to be made to sections B, F, and I unless there's a professional supporting them in doing so by way of a written advice. So it is important also just to keep an eye on section K as to the reports that have been used. There have been situations, unfortunately, where plans have gone through the annual review process, but maybe haven't been amended as they should have been. And then reports are significantly outdated in section K. So it is important to keep an eye on those reports. And then the remaining sections, health and social care, unfortunately, they're not as enforceable as sections B, F, and I. That does sound strange because this is a legally binding document, but they are not as enforceable as the education sections B, F, and I. Health and social care can be pursued in respect of any challenges by way of judicial review, but they are not covered at the moment by tribunal, only by way of recommendations. A tribunal can look at health and social care and set out recommendations, not orders. Orders can be applied to the educational sections of this plan. Health and social care, they can only make recommendations. Social care sections of the plan, it's essentially governed by the Social Care Act, and you would have to go through a separate social care assessment, which will then feed in to this particular plan. But sections B, F, and I, you can take to tribunal, you can challenge them, and orders can be made against them rather than just recommendations. And then we talked about personal budgets before, they go into section J. Now, personal budgets, as I mentioned, an example that I can use, we evidenced by way of a physio report that physiotherapy was needed, direct physiotherapy from a physiotherapist on a weekly basis, but the council could not provide that. They acknowledged the need for it, acknowledged the evidence for it, so then said, okay, we'll give you a personal budget to be able to instruct an independent physio. And that's what was done. And we were able to provide the relevant costings to be able to get that lump sum of money. Personal budgets can also be used, and more so currently, for what's called an education otherwise than at school program. So essentially, we're looking at some type of home education there. Coming on to a bit more detail on some of these sections. So outcomes, they can be long-term, they can be yearly, they can be termly, but they just need to be monitored and revised on a consistent basis. If one's achieved, what's the next one? Examples of provision in section F. So the provision in section F, the key words are it's meant to be specified and quantified. That comes from the code of practice and is applied. And there is various case law which backs this up. There should be no room for doubt as to what provision should be delivered. So we're looking at frequency of provision, we're looking at who's going to deliver it and how long for. We've got some examples there on the slide in terms of, we've got an experienced TA should be delivering it on a weekly basis. We've got the 15 minutes. That's the level of specification that should be in a plan. Unfortunately, councils do try and avoid that because it does mean that they are committed to a certain element of funding. They are getting better. So my cynicism is somewhat, it's not all there all the time. They are getting better. However, it is often the case that I've seen things like access to speech and language therapy, access to OT, or OT will advise on this as and when. That tells us absolutely nothing as to the frequency of what should be delivered and by whom. And particularly in respect of therapies, you can have a lot of, physiotherapy, occupational therapy in a plan, but who's actually delivering it? There's direct therapy, which is delivered by the actual physiotherapist, occupational therapist, or speech and language therapist. And then you've got indirect therapy, where it's delivered by TAs who are advised by a particular therapist on a maybe termly occasion, maybe a one-off occasion. I'm not saying indirect therapy isn't workable, because it is, and it can ensure that outcomes are followed through on a consistent and daily basis. However, we need to look for a balance between the two. But it will be determined on a child's needs. How to address the drafting of an EHCP. So essentially, when can parent and any other professionals have some comment on the content of an EHCP? There are various different stages where draft EHCP will be presented by the council, and then parents are sent a covering letter saying you have 15 days to make comments. Even though this 20-week process isn't exactly strictly applied, this 15-day sort of response period is very strictly applied. And if a response isn't given within those 15 days, silence is deemed acceptance. So it is really important to respond within those 15 days. If more than 15 days is required, a request needs to be made as soon as possible to the council for an extension. And you can get a draft EHCP, obviously, following potentially a reassessment of need if you've already got a plan, or following an annual review or a transfer review. A transfer review is simply an annual review, but done at key stages of change. So you're looking at nursery to primary, primary to secondary, secondary to college. And as I said, you can make representations on that draft plan and the content of the plan. If you are going to make comments on sections B and F in particular, has to be supported by professionals. There must be a report that can be referred to. And the content of the EHCP can also be considered at mediation and at an appeal if we get that far, essentially. Enforceable decisions. As I've said, in terms of enforceable decisions, special educational provision is the most enforceable. Health and social care isn't as enforceable, wasn't covered as it should have been. You can pursue judicial review in respect of those sections. It's unfortunately time consuming and costly, so it's not really advised to go down that particular route unless it's really required, but special educational provision is covered. And hopefully when it comes to health and social care provision, the enforceability of it could be addressed, fingers crossed, maybe even within the coming SEN reforms. But I know that Tribunal, they're making those steps towards trying to do something about it by making recommendations on those particular sections at the very least. Mediation has to be considered when you get a decision letter from the council in respect of any no or following any particular process. The mediation, you'll get a mediation telephone number, and you'll be asked to call that number, listen to that information, and then decide whether mediation is going to be pursued or not. Entirely up to parent as to whether they pursue it or not. Parent has to make that call and has to make the actual telephone call and then make that decision as to whether mediation is worth it. If we're only looking at sections B and F, then I would say mediation could be worth it. If you're looking at placement as well, often it's not. And also, when it comes to mediation, unfortunately, what's made it even further ineffective is that often a decision maker from the council isn't attending. So it's important when you're talking to the mediators to emphasise that you want a decision maker there who can make a decision on the day and not have to take it back to their management at the council, because mediation is meant to be a way to reach agreement on the day and try to avoid an appeal. And that request to look into mediation has to be done within 2 months of the written notice of the LA's decision. Appealable decisions, essentially, every time the council says no, you will get your appeal rights. You have 2 months to lodge an appeal. And that's to the Special Educational Needs and Disability Tribunal. They are completely separate from the council, completely separate from parents. They will consider all evidence before them and then make a decision on the best interests of the child. With sections B, F and I, they can make orders. With a health and social care, they can only make recommendations at this stage. Tribunal powers. As I said, they can make various orders when it comes to sections B, F and I. When it comes to tribunal, so you can appeal against a refusal to assess at the very start, when we go back to that very start stage. You can look to appeal a refusal to issue a plan, an EHCP. You can look to appeal against the content of the plan. So you can look to appeal against sections B and F. You can look to appeal sections B, F and I, so if you're looking at school placement as well, or you can just appeal section I. If you are happy with sections B and F, you can just look at placement itself on its own. But once a tribunal order is made, it must be followed by the council and applied. If it's not, legal action can be taken. And we have come to the end. I will stop sharing.
Thanks, Govinda. I'm just going to stop the recording if that's okay, and we can then address everything.